Have you ever wondered what kind of stuff you can actually give away or sell? Like, can you sell all the fish you might catch tomorrow? Spoiler alert, no. Well, that's where Section 6 of Transfer of Property Act comes in. Namaste, this is Abhinandan and we are about to dive into the world of property swapping. Although Section 6 as a general rule says that property of all kinds may be transferred, but there are almost 10 exceptions to this section. They are given under Clause A to Clause I of Section 6. Let's explore them one by one. First of those exceptions is spes successionis. It means the expectation of getting the property through succession. It is just a chance of being succeeded as an owner of a property. Let us look at 3 cases where this chance of succession is non-transferable. First, chance of an heir apparent. Heir apparent is a person who would be heir after the death. There is a maxim in English law that no one is the heir of a living person. Becoming an heir is only a chance. The heir has to outlive the person and the person must not make any will to assign the property to anyone else. If that happens, then the heir apparent will not get the property. Hence, the heir apparent cannot transfer his apparent right over the property to anyone else. In Amrit Narayan vs. Gaya Singh, the Privy Council held that the right of reversionary under Hindu law is also a chance. Hence, it cannot be transferred too. Next is legacy. Legacy means a chance of getting the property through will. Can you spot the problem here? Yes, it too is just a chance. That means the owner before dying can change the will or make a new one and assign it to another person. So, this too cannot be transferred. Next is any other possibility of like nature. It includes all other properties of similar nature. And it is left for the court to interpret according to each case. For example, no one can make the transfer of the fish that will be caught in the next cast of the net, as no one can take the guarantee that fish will be caught at all. This again is just a mere possibility. Second exception is right to re-entry. A mere right of re-entry for breach of a condition subsequent cannot be transferred. For example, A leases B his land on a condition that he must not dig a well, and if he do so, A can re-enter and take the land from B. Let us suppose B digs a well. Now, A has the right to re-enter the land. But the catch here is that A cannot transfer this right alone to anyone else. The third is easementary rights. These are the rights which exist for the beneficial enjoyment of the land and is exercised upon the land of another person. For example, if A's land is surrounded by B's land from all sides, B is required by law to give a pathway for A to enter his land. Hence, A has easement rights over B's land. Now, A cannot transfer this pathway to anyone else. But if he sells his land, the easement also gets transferred. An easement cannot be transferred apart from the dominant heritage. Fourth exception is restricted interest. An interest in property restricted in its enjoyment to its owner personally cannot be transferred by him. This means that a person's right which is only for his enjoyment cannot be transferred by him. The religious office of Mutawali, of Waqf or Mahant of a Mutt are included in this clause. Fifth is right to future maintenance. Maintenance is for the benefit of the person to whom it is granted. Therefore, it must not be and cannot be transferred. This clause was inserted in 1929 through an amendment. Sixth exception to Section 6 is right to sue. Right to action for damages in tort or breach of contract are bare right to sue, and therefore they cannot be transferred. For example, A publishes a libel on B. Now B has a right to sue A for defamation, but B cannot transfer this right to anyone else. But B can appoint an advocate to represent him in the case. Next exception is public office. This clause provides that a public office cannot be transferred, nor does the salary of it. These offices are held on merit, and it is important to ensure the dignity of the office and proper performance of the duties. Next exceptions are stipends and pensions. The 8th exception provides that stipends allowed for military, naval, air force and civil pensioners cannot be transferred. But provident funds, gratuity and other retiral dues can be transferred as per the courts. The clause H includes the classes of case where the transfer cannot be made. They are transfer opposed to the nature of interest. If the nature of the property to be transferred does not admit such a transfer, then the transfer is invalid. The things which belong to no one like ocean, air, etc. cannot be transferred. A property otherwise transferable may not be transferred if the transfer is for an unlawful object or consideration. Or if the transferee is disqualified by law from transferring, then too the transfer cannot be made. The 10th and the final exception deals with untransferable interest. It includes a tenant's right to sublet the property, which is only valid if permitted by the owner. The same applies to lease agreements. They cannot be transferred without the owner's consent. So there you have it. A crash course on what you can and cannot transfer under Section 6. If you have any doubts, please let us know in the comments. As always, thank you for watching. This was Abhinandan and you were watching Law Quest.